Okay. I'm not starting a minute early. We're good. Okay, that's on silent.
Oh, yeah, good idea.
Yeah. Make things silent. It's almost there. Like 30 seconds. I figure you really shouldn't start early. Somebody came.
Is David coming tonight? David Igliozzi? Okay.
Okay. First one, Starbucks, Chipotle. Okay. Good evening, everyone. The North Smithfield Town Planning Board meeting for Thursday, September 28th is called to order at 7 p.m. First in the order is, first order of business is a roll call. Dr. Benoit?
Here.
Ms. Marandola?
Here.
Mr. Porter?
Here.
Ms. Menard?
Here.
And the chair is here. Absent are Dr. Roberts and Mr. Keene. Next item, review of the August 24th minutes. I'll give you a moment to look. Have any questions or concerns?
I'll make a motion to approve the minutes.
And second, those in favor?
Aye.
Aye. Opposed? None? Minutes are approved as is. Next item, any planning board members need to disclose any potential conflicts with the matters on the agenda for this evening?
Mr. Chairman, I have a granddaughter that works for Chipotle part-time. Has nothing to do with that.
No objection.
I think we can deal with that. Okay.
I do work for CVS Corporate, which I believe is in the Waterway. But I'm so sorry. I do work for CVS Corporate, which I believe is in the Waterway. I believe we have a DC in
For
the
the-
Waterway.
You
So,
do have a distribution center in the overlay district. That's
So-
correct.
That's all I got.
I don't know that that's an issue.
I don't know if it is either.
It's not an issue.
I didn't
You're,
think so.
Making sure.
you're not a decision
Mr.
maker.
Chairman, would you use the mic? I forgot my hearing aids.
I will. Thank you. I forget also. Okay, and anything else? Any other employment issues or anything that you want to disclose? No? Good. Next on the agenda, disclosure and notice. Do any planning board members need to disclose any ex parte communications about any contested or material adjudicatory facts or opinions concerning the merits of any application before the board this evening? Hearing none. Declaration of voting members. Since we have 5 present, we're all voting members today. So first order of business, public information meeting, major land development master plan, Starbucks and Chipotle. The applicant is Alrig USA, 82 and 88 Eddie Dowling Highway, Assessors Plat 21, lots 22 through 24, 49, and 58. Mr. Carrillo.
Mr. Chairman, board members, this is a project located along Eddie Dowling Highway, land associated with the former Landmark Medical Center. The applicant is looking to merge several lots fronting on Eddie Dowling Highway, subdivide the property to create 2 lots out of 5 lots. A portion of the property along Eddie Dowling will be merged back with the former Landmark as part of their parking lot. The other lots will be merged together to accommodate 2 fast food restaurants with associated parking. The fast food restaurants and associated parking will have a second full-service access along the most northerly portion of the property.
Good evening, Mr. Chairman, members of the board. Michael Resnick on behalf of the applicant. And apropos to your planner's remarks, this is relative to Assessor Plat 21, lots 22 through 24, 49, and 58. We are in full compliance with zoning. There is no zoning relief required. I can tell you that it's in full conformance with the comprehensive plan, full compliance with parking, as Mark noted. While it's not an item that is required for master plan, I did want to inform the board that we have submitted for the one state permit that we would need, which is a PAP permit from RIDOT. We did receive a certificate of completeness from RIDOT. It is under review, and it's our engineer's estimation that we'll be getting feedback, if not an approval from them in the next couple weeks. So if we are lucky enough to obtain master plan approval, it would be our intent to be back before you fairly expeditiously with respect to a preliminary plan. I will note, I think that Mark described the project perfectly, so I'm not really going to go through much more of those particulars. I will say that I've reviewed the proposed findings. I've reviewed the staff's recommendation relative to the conditions to be attached to this master approval. We have absolutely no objection to any of those. And I'd let you know that we're joined here this evening by the project engineer, Josh Klein from Smithfield Engineering, and he'd be happy to answer any questions that you have relative to the proposed development. Thank you.
Okay, thank you. It probably would be good for the engineer to come up and do a walkthrough of the project.
All right, good evening. Thanks for having me. Josh Klein, Smithfield Engineering and Design. I am a licensed professional engineer in Rhode Island, as well as I think 6 or 7 other states now, pretty much everywhere in New England. We are the site civil as well as the traffic engineer for the project. We have a lot of experience, kind of both with this client, both with these types of uses. So I'm happy to kind of walk the board through. I'll try to stay near the mic. So I brought with me today just a colorized version of the plan. Takes the plan that we as submitted, we just put a little color to it, bring in some of the landscaping just to help to talk about it. So we are proposing 2 buildings. Today there's kind of 2, we'll call them like residential type uses. I don't know if they were used for maybe other purposes in the past. They look to be abandoned today. And then the project consists of kind of modifying a property line slightly just to kind of help create a better parking lot today. So one of the big advantages of this development is it gives us an opportunity to kind of reconfigure the access and the parking and the layout of this kind of ancillary lot. We're also, as part of the project, pulling this parking lot off the road, so we're meeting that buffer requirement across the front. I don't know if this comes off, but you can see kind of behind me, both uses will have a drive-through. So they have been designed to kind of work in tandem to avoid any type of conflicts. One of the nice features about this design and working with the town planner is there is a bypass right before the tenant on the left's drive-through. So again, if someone's been waiting and someone's taking a little bit too long at the menu board, there's a cutout, which is a really nice, kind of feature of this design. I'm happy to get, more technical, obviously, as part of our PAP submission or PAP. We have kind of prepared stormwater and grading and things of that nature, but I know at this time we're really just excited to introduce the project and kind of this be our first step in a 3-step process to get this project to the finish line.
Okay. Questions?
There is only one entrance and exit at the northerly side.
So the project will have a driveway that's right along the state highway, and it will also have cross-access with the property behind us, which is located just to the top right corner of the page that I'm pointing to, and that will allow someone to kind of exit through the parking area to the top of the page, kind of the northeast, and kind of work their way back out to the highway.
And Foley Hospital has granted that approval.
So I know that they're working together. I'm not sure if there's anything in writing yet.
Yeah, with respect to legal documents and easement, that would be something that we'd be providing to the board at preliminary. That's being negotiated. It's not something I have executed now. That's been discussed with Mark, and we will have that arrangement before we're back before you for preliminary. That's all I can say this time.
So that exit that Dr. Benoit is questioning, it's not shown here on that drawing. Is that on the essentially driveway that comes down from Dowling Village?
If you go to sheet,
No, on the right-hand side.
I'm just having
Oh,
her,
yeah. Okay.
having her pull up the overview. I'll try to speak loudly so everyone can kind of hear me. So you can see here, there's the driveway, a little blurry, but you can see you kind of make your way
Mhm.
out. Usually I have a laser pointer on me, but you would kind of exit up through the parking area, and if you scroll up a little bit, this is that existing driveway that exists today. So I know at one point in time there was maybe an exit only
Mhm.
here, kind of, but that's going to remain closed. It would be this driveway here, and then that new driveway that's being proposed as part of our DOT permitting effort.
Okay, all right. Anything else, Dr. Benoit?
Do you have sewers available?
Yes, there is sewer available.
Okay. Anything else?
Mr. Chairman?
Yep.
So with regard to the overall property, I believe Landmark controls all of the property, so they're negotiating actually those cross easements with the property owner that they're buying the property from, so that I imagine they will be successful. And if you look at the stipulation number 7 addresses that specifically, that at the preliminary approval stage, we're asking that there be adequate cross easements across all of the properties so that, you know, each property can use the others.
But in the end, Alrig will own the properties that
Right, that's
you're
right.
developing.
Correct.
Landmark will continue to own a piece of what is now that, well, apparently unused parking lot?
Yeah, correct, and we'll hold an easement. That's something that will be done simultaneous with the closing on the property. My client, the applicant, Alrig, has control relative to a purchase and sales agreement
Okay.
with the.
Because it looks like, so that'll just remain a parking lot. I mean, you're altering it a bit to push it back, but it remains a parking lot much like it looks like today?
Correct. Yeah,
And it will
we're-
be used by both the hospital and the restaurants, potentially? If you're having a really good day, you know?
Yeah, that's, I think they're kind of working the terms out, but one of the nice parts, I mean, we have adequate parking just on our property alone. So we
Mhm.
do have enough parking on the site to support both uses. And then again, as part of it, we're keeping that area as a parking lot. We're just kind of cleaning it up, helping with the flow patterns, getting a little bit more landscape.
Okay,
Yeah, and just to be clear, Mr. Chairman, with respect to parking, per the ordinance for these uses, there's 1 parking space needed for every 4 seats at the restaurant, with a total of 98 proposed seats. 25 parking spaces would be required. This plan has 36.
36 without the split parking lot?
Yes.
Okay. All right, thank you. Dr. Benoit?
Starbucks is notorious for having a very slow line. How many cars can be stacked in that plan?
So I can definitely speak to the stacking. I think this actually does not have it on. If you go to sheet C4, which is 1 down. So this shows, you can see it's a really nice, you know, we work on it with a lot of different tenants. We have a really nice kind of queuing on this site. So I believe it's 16, but I can double check, 2, 4, 6, 8, 10, 12, 14, 16. I'll have to confirm, but it's 16 to 18 can be handled in the queue lane alone. And what's nice about this project, kind of strategically locating this driveway, is even in a situation, right, where someone's a little bit slow maybe to move ahead, you're not gonna run into a situation where this would ever back up onto the state highway.
And just one thing that I would add is, I've heard that concern in connection with our preliminary application. We'll be prepared to address queuing and internal traffic, external traffic issues in a better way. We'll also have the benefit of getting feedback from RIDOT with respect to the PAP permit at that time. So those are materials that we'll be prepared to discuss in a greater detail in connection with our preliminary application, which I think is the normal course. But based on, I think that what's been done here might be a little more than even normal in a master plan. There has been due diligence done to the queuing. There was a lot of work done with your planner and staff relative to that exit that was just referenced, the emergency hatch, I'll call it.
Could you, I was just going to ask, that's the cutout you were talking about. Could you point to that a little more clearly?
So it's, if if you have the plan in front of you, it's easier to see, but it's right kind of behind.
Oh, it is that middle.
User on the right, so there's a striped area before the menu board.
Mm-hmm.
So someone would be able to exit through and then leave through the bypass lane with the user.
Oh, so it's a
on the right.
bypass lane that goes around the people who are picking up their food from the other, oh, okay.
Correct,
Okay.
yeah, there's a bypass
Yeah, I couldn't see that it
lane
was two lanes.
along
Yeah.
the food user on the right, and then there's an interconnection to allow someone to kind of, you probably heard the term escape lane almost, that they can kind of escape out of the drive-through.
Right. Change their mind, they just want a regular cup of coffee, they're, yeah, I'm out of here. Got it. Okay. That's actually, in defense of Starbucks, I can see why they have longer lines when you're making some of those complex coffee drinks,
That's right.
Takes a while.
That extra creme, the froth on the cappuccino.
Yeah, and then the twist, and then signing their name on it, and something else, okay, so that answers that. So could you walk us through pedestrian traffic and how that plays with the, takeout traffic and all that?
Yeah, I'm happy to kind of touch on some of the pedestrian points. So we will be kind of redoing part of the sidewalk along the
Mhm.
frontage. We are providing an ADA compliant path that runs from the public right of way to the tenant on the right, as well as that ADA path continues and connects to the tenant on the left. There is a designated crosswalk that comes from the kind of the parking area towards the bottom of the page that connects to the tenant on the right, and again, another crosswalk that's signed and striped to kind of connect the two tenants together. We also are providing a path back to the hospital, so someone from that parking area, or someone's taking a little bit of break, has a nice path to be able to walk, and it's nice with the location kind of out there today. There's some benches, and you can tell this is maybe where they sit today outside, so it's nice and kind of close to where that connection would be. From there you kind of have more of a commercial style parking lot with people being able to kind of get to these designated crosswalks and points to be able to get to the site.
So I'm noticing that pathway, which of course ADA compliant, very good, but it goes right across the escape route.
So this path in the back that I think you're referencing?
No,
behind
I'm looking at
buildings?
the path, if you're looking at the
Between the two
takeout window for Chipotle, right, which is the right-hand restaurant, right? Well, go down to, so where you showed this escape path coming out, bring that, isn't that the crosswalk?
So people will have to cross the drive-through lanes. It's just inevitable. So we do have crosswalks that are designated
Sure.
across these areas. They're signed or striped for
Here-
those crossings. In terms of the connection to the property to the north of the hospital, they wouldn't have to kind of, they would
Sure.
come down at some point again, they could cross over. And then that sidewalk you see in the back here
Mhm.
that comes across, that really is designated for the employees to get to the trash.
Right.
We don't expect people really to come in the back. This door and this door in the
Right.
back of the restaurant
Sure,
won't get you in. So again, we have those kind of crosswalks. along
right.
the front.
Well, and, crosswalk going through cars that are essentially parked and moving forward one car length at a time is one thing. My concern is with the one that's in front of the escape path, because that's someone who got impatient, decided to come out, and if there's another car getting their takeout, they may not see someone in a wheelchair or on a scooter, whatever. And so there's a bit of a blind spot in my eyes for someone who's coming through, hopefully at not more than 10 or 15 miles an hour, but they're not moving at that one car at a time pace. They're escaping. So I'm wondering what can be done to mitigate that.
Yeah, and this is probably a great topic for us as we get to the preliminary stage, is kind of working with your staff to figure out
Okay.
maybe a solution. But I will say, this is stop control, so there's a stop bar here.
Oh.
There's lettering actually painted on the
So
ground. that
essentially a
says stop.
crossing gate, like you see at a,
Not a gate, it's a stop bar, so it's a painted stop line. And then there's 18-inch painted stop lettering, and we even kind of
But
went
that's-
above and beyond and have
yeah.
a stop sign. So, someone that is, unfortunately, they're kind of avoiding three very typical measures that are used to kind of
Okay.
stop people. And that is another reason why we push the crosswalk kind of up as much as we could, because it sets the car car, it's tough to see on the blurry screen, but it sets the car that's waiting back about 10 feet. So if someone were coming around, again, they would see the stop written on the ground, they would see the 18-inch white line, and they would see the two signs in front of them.
And that's all
They also
before that's all
still-
before the crosswalk?
Correct.
Okay.
And they also still would have a sight line to the person at the ramp, because we've actually shifted these cars back a little bit. That's why
Okay,
this one's pushed a little bit forward versus these two,
I see.
because we did want to have that sight line visible.
Okay,
That said, we're certainly willing to entertain other
Appreciate
safety
it.
mechanisms, absolutely.
Right.
And we can work,
Right.
yeah.
okay, great. Did you have something? Okay, Dr. Benoit?
Will you have tractor trailers supplying their goods to these operations? And if so, where are they going?
Yeah, so we're working, with the applicants on the kind of the final loading operations. Typically it's box truck. There is the potential for smaller tractor trailers. They would come during off-peak times when, they're not in operation. So we typically see them either pull kind of in front of the store, temporarily unload. It might be a 15, 20-minute unload. One of the other nice advantages of this site is we kind of have this unused or, kind of significantly underutilized parking area that could also be used for that operation. So we'll make sure when we come kind of for preliminary that we have like a really nice kind of finalized loading statement and operations plan with the applicant.
And you implied, especially for a small tractor trailer, like a 30-footer or something like that, you're
Yeah, we-
implying that they're coming in off hours, when
Correct.
when
Yeah,
the
no
restaurants
matter
are
what-
actually closed.
No matter what, it will be during off-peak. So they may have some deliveries in the middle of, kind of in between some of the peaks that we see, whether it's the AM or the PM. But again, that's something we can definitely make sure we have together for preliminary.
Okay,
And I think at preliminary, when we make that presentation, I'm sure that my client would be amenable to some conditions relative to when
Right.
that type of loading would occur in the decision.
yeah, I would suggest taking a stab at an actual schedule of when they're going to be allowed, when they're not going to be allowed, or what type of truck is allowed at different times. That would go a long way, so. Okay. Mr. Porter?
Considering Doc just stole one of my questions about deliveries.
That's what he does.
I'm going to pop in now, in case he steals any more. We were just talking about peak hours and hours of operation. When do you anticipate those hours of operation going to be?
So I know we're still kind of finalizing those with the client.
Okay.
So we can definitely follow up. I believe they're kind of the typical kind of restaurant, fast food user hours. But we'll definitely kind of get those finalized and back to the board.
Okay, that'd be great, thank you. And then on your entrance and exit onto 146A, is that going to be a new curb cut, or is that an existing curb cut that you're utilizing?
So it would be, it's kind of near a location of a driveway, but it will be all brand new.
Okay.
That's what we built.
My concern is just knowing that area and the amount of traffic that area gets, is if people are going south on 146A, turning into that area and using that as an entrance. So one of the concerns I have was knowing that area gets to be quite congested sometimes, is perhaps we put in, or perhaps alter the entrance and exit to just be on, allow 146A north to go in and out of that, and then folks that are going 146A south to use the intersection in the light and traverse, I know it's a little longer ways around,
Yeah, they
but
get in the
perhaps
other- yeah.
traverse through the hospital parking lot, just because, as the other members of the board have alluded with the Starbucks coffee, we don't want to have another, if there's a line here that's now spilling out onto 146A, and people are trying to get down to Providence, but they're now waiting to get their coffee from 146A South, that area might become a little bit more congested. So I would encourage you to look at that. I know you guys have done the traffic study and everything, and I read through that, but it's just, the nature of the beast that's in that location. I wish your plan was just pulled ever so slightly more so we could see where the striping occurred in relation to your entrance and exit there. But I would encourage you to take a close look at that in the event that we, want to avoid any traffic collisions or anything like that, especially cutting through cutting across 2 lanes of traffic when you're coming 146A south.
Understood, and again, we'll also be getting comments back from RIDOT, so we'll take all of that into consideration before
Great.
we come back to the board.
I think you raise a good point that maybe for preliminary, if one of the drawings could include the striping, so we see
Absolutely.
exactly how it's going to work, that'd be great.
Yeah, we can kind of get the colorized version updated to give a little bit more.
Okay. Anything else, Mr. Porter?
That's all I have.
Anything else? Mr. Bernard?
Are you proposing, or is it too early to state, are you gonna have any parking lot lighting in the parking lot to the right?
So the parking lot to the right, it's a little too early to state, but we definitely, kind of our property line, which runs kind of through these 2 parking areas. This area is all new lighting, but it's definitely an answer we can get as part of preliminary.
And all of that lighting will be dark sky compliant?
So I know we would be looking to do full cutoff LED downward facing. You know, one of the challenges you hear with the term dark sky compliant is it's a term where a lot of lights provide the same intention, right? They're downward facing, they're LED, they're full cutoff. It just might not have the stamp. So again, if it would be a requirement of the board, I mean, obviously we'll work with our applicant, but we would be doing kind of shielded, downward facing, full cutoff LED lighting.
And I would just add, I think that a full lighting plan is something that would normally be submitted at preliminary, and I have not studied the ordinance in that regard, so I think we'd be in a much better position to address that at the next stage. Obviously, we're gonna be in full compliance with the ordinance, and whether there's some extra conditions relative to a lighting plan, we'd be certainly happy to entertain them. But dark sky is a term of art, and you have to be very careful how it's used, because it means different things to different people, and it's really based on how it's defined in your ordinance. For instance, many municipalities look at it a little bit differently. I was just in Charleston last night, and their idea of dark sky compliance is quite draconian. Yeah.
How about signage? Is it strictly gonna be building signage, or is there intention to be freestanding signage?
There is the intention to do a ground sign. I don't have any more details at this time, but we are proposing a ground sign.
When you use the term ground sign, low or upright tall sign?
I don't, at this time, I know they're still kind of working out the details of it.
Okay.
Okay.
Thank you.
Is that it? Dr. Benoit?
At preliminary, I'd like to know about snow storage and removal.
Understood.
Very good. Anything else? Before we,
I'm done.
Oh,
I'll make a motion.
oh, I
to
doubt
use
it.
the master plan.
no, we're going to make a motion to open the public information meeting.
Sorry, I jumped the gun.
Yes, you did.
Make a motion to open the public hearing.
Do I have a second?
Second.
We have a second. Those in favor? Aye. Okay. The public information hearing is open at 7:27. Anyone wishing to speak, please come up to the podium, introduce yourself, no matter how well we know you, and
Good evening, everyone. Yes, my name is Paul Zwolensky. I'm the town administrator, but I'm actually here as a resident, 19 Bourget Court. Doc, the question I had was about snow removal and stacking. Thank you for asking that. Quick come to mind, I know it's only master plan, location of dumpsters, hours of operation,
Yep.
opaque fences. Is it up there? Because I couldn't see it from way over there. And it's
the
only
the
master.
dumpsters, I think, are.
Are they? Yeah, okay.
Yeah.
So as I was squinting to see this, I believe that this is the proposed cutout for the emergency exit or the escape path, is that correct?
It's a kind of dual purpose bypass lane, correct?
Okay. So I get this, that, I mean, you'd have to work your way to that point to escape. What happens to these cars in the queue to the west of the escape lane? They're kind of stuck there. Is there any provisions for escaping if you pass that?
Well, they've ordered food. They've ordered something if they're at that point, correct?
I hate to say this, but I've ordered food and got tired and just took off.
Oh, really?
Oh, yes.
All right.
It's happened before. So, and as much as I look like I don't want to skip a meal, I've done it.
Okay,
So, something to keep in mind
All right.
through the chair, right?
sure, absolutely.
I think that's about it, and I appreciate you letting me ask the questions. Thank you.
Great. Thank you, Mrs. Lindsay. Anyone else? Going once? Going twice? Do we have a motion?
Make a motion to close the public hearing?
And we have a second. Those in favor?
Aye.
Aye. The public hearing, information hearing is closed at 7:28. So with that, any final questions, comments for the applicant from the board? We're good? Okay. Time for a vote. We have a set of stipulations. Why don't you walk through those?
Who are you asking?
Would you mind walking
Oh,
through
sure.
those?
Just for the record, the planning office recommendation comes with 8 stipulations. 1, that all necessary state of Rhode Island permits shall be issued prior to preliminary approval, including but not limited to Rhode Island DEM RIPDs, OWTS, and underground injection control permits, and a RIDOT PAP permit. Number 2, that a sufficient number of fire hydrants shall be located within the development, subject to the approval of the North Smithfield Fire Department prior to preliminary approval. Number 3, that all exterior lighting shall be contained on-site and directed away from and/or shielded from the abutting properties. Number 4, that a soil and sediment control plan shall be required at preliminary approval in conformance with zoning section 18, soil erosion and sediment control and stormwater pollution prevention plan. Number 5, that the applicant shall provide an excavation construction plan which may be combined with the soil and sediment control plan designed to mitigate the impact of construction on the abutting property, which shall include but not be limited to construction access best practices for dust control and vibration and hours of operation prior to preliminary approval. Number 6, that a landscape plan designed by a Rhode Island registered landscape architect shall be required prior to preliminary approval. Number 7, that cross easements for parking and access between and among lots 22 through 24, 49, and 58 shall be provided prior to final approval. And number 8, that an administrative subdivision merging 5 lots into 2 lots to comply with the development plan shall be recorded as a condition of final approval.
Thank you.
And with those stipulations, I will make a motion to approve the major land development master plan at 82 and 88 Eddie Dowling Highway.
Okay. We have a motion to approve with a set of stipulations. We have a second. Roll call vote.
Yes.
Tonight. Ms. Marundella?
Yes.
Mr. Porter?
Yes.
Mr. Bernard?
Yes.
And the chair votes yes.
Thank you,
And-
Mr. Chairman, and thank you for your comments this evening, and I'd also like to thank your staff, your planning staff, for helping us to
They're
refine
good.
this over the past couple
Yeah.
months.
And I'll say on behalf of my son, he would very much like to see a Chipotle here. And I also feel that it's a sign of North Smithfield coming up in the world that we've warranted the attention of Starbucks.
Yeah,
I mean,
we're gonna-
that
we're
sort of
gonna
puts
get-
us on the map,
We're
doesn't
gonna
it?
get in front of you at preliminary as soon as possible.
All right.
Mr. Chairman.
We look forward to it. Thank you. They do have like a 2,000 calorie dish that he gets at Chipotle, so he's a hummingbird, so he can eat that. Okay, next on the agenda. Amendment to the town zoning ordinance, section 6.19, water supply protection overlay district. The applicant, the North Smithfield Water Supply Review Committee. Zoning amendment, they said zoning ordinance amendment and corresponding map amendment to section 6.19. So this is a continuation of the last meeting, correct?
Yes, Mr. Chairman, I believe at the last meeting, some of the discussion related on perhaps the watershed overlay committee reaching out to the business community. My understanding is that there was at least 1, if not 2 meetings with some business representatives, and I think perhaps the councilman is here to provide an update to the board with regard to those meetings.
Yep. Mr. Ossier.
Just give me a second. Good evening, everyone. Do I need to state my name? It's okay. Douglas Ozier, Chair of the Water Supply Review Committee. So as the planner had said, I forget the date, I think it was August 24th. One of the requests out of the planning board was that the Water Supply Review Committee meet with some of the local businesses in town and hear the concerns and hear any additional information as it relates to the potential impact on the proposed changes within the ordinance. The Water Supply Committee did just that. I believe the date was 9/6. We did meet with a few of the local businesses in town. The meeting was roughly, I believe it was just shy of 3 hours. There was a lot of education on both sides, a lot of good dialogue and conversations, and the group decided that it would further take every recommendation under consideration, and was hopeful to follow up prior to the public hearing with the town council. I know that this meeting was delayed, and so since then, there was also an additional meeting with the town council where additional concerns have come out. The Water Supply Committee did meet last night, and there was at least one business representative represented there. But the intent is to hold a series of further discussions with the local business community over the next 3 to 4 weeks prior, just up until the second continuation or the continuation of the public hearing with the town council on 11/20. Some of the things that have come up and that are under further study is as it relates to businesses and particularly those within the industrial area of Industrial Drive, is instead of looking at maybe just the overreaching special use permit, and overreaching what I mean is instead of just saying every land use activity in that land use category of manufacturing and industrial, going through and looking at the land uses as it relates to some of the higher intensity use, and going through 5.4 specifically and saying yes, no, which ones are innocuous, which ones maybe require further attention as it relates to a special use. So essentially the group would be looking to study exempting existing business expansion in addition if the proposed expansion does not result in any increase in the impervious area, but also looking at what is the mechanism and the trigger for requiring a potential special use permit. And so one of the areas to do that would be potentially allowing a business to expand their building footprint by way of an additional accessory building not to exceed just, for example, like 20% of the existing building's footprint. There may be ways to play with that with depending on square footage, maybe with certain percentages change. Any non-conforming pre-existing, maybe this would apply as well to those areas. But that's up for discussion. And then also to amending, as I said, section 6.195 permitted uses by looking at the land use table and having that updated as well. So any innocuous use like an office, bank, general warehouse, et cetera, would not need to go through this process. So those are some of the areas that came up. Some of the other reasons for the proposed changes was to kind of streamline and clean up any language, kind of create one source of truth. Obviously, the intention here is not to conflict with DEM, so part of this process and following up on the public hearing and some of the feedback that I heard would be looking at areas where maybe it just needs to point specifically to DEM and say that you would be in compliance with all permitting process as outlined by DEM. That's kind of what the ordinance does now, but I think there needs to be clarification there as well to not try to say that the local level is going to try to override the state. And then to also clean up any grammar, vocabulary, and any other inconsistencies. One of the examples I'll use is the old ordinance says it shall contain, I think, waste or something like that, and it should be shall not contain hazardous material and waste. So there's been some typos that have been going back to the existing ordinance pre any revisions in 2020 that should be cleaned up. So those things have also been looked at as well. But I'm happy to answer any questions, any further follow-up or feedback or recommendations as well. Thank you.
Any questions from the board? Dr. Benoit?
If I read something in the briefs, let me know if it was accurate or not.
Mm-hmm.
That the state is going to streamline zoning and planning on the state level
Correct.
in the near future.
Correct. Correct. Starting in January of '24, the state last year, I believe, passed a law that allowed for the planning board to kind of act as a super board, I guess, and would be able to authorize as part of a unified review process at master plan. Correct me if I'm wrong, Mr. Planner. But would offer the ability to offer and approve a special use permit at the beginning application. So you would be essentially removing the potential of up to a few months in the process. You won't have to do the dance of going back to planning and zoning. It's kind of streamlined, which is a benefit to any applicant that's coming through.
I'm going to comment. probably shouldn't. But you made a comment that the state is going to try to create the planning board as a super board. We already are.
Well, not as it relates to special use.
We vet these applications up and down, and everything that we ask has to be provided from the attorney or the engineer.
Correct.
We don't need a duplicate process.
But, no, but what it does,
Scare business out of town.
So
We
can I
can't
challenge
have it
you?
coming
Can I
in.
ask you a question though? So who approves the special use right now?
Special use for what?
For any special use application currently, outside of the water overlay, throw that off the table.
Well, that's theoretical. What's before us?
No, it's the zoning board approves the special use criteria right
Right.
now. You would be saying to the zoning board essentially under the new law that the zoning board is not the
No,
author of that.
I'm just commenting that the term super board, I feel we, the members of this board.
Yeah.
You guys do a fantastic job. I'm not using
Right.
it to degrade
he's
anything that the
talking in
planning
terms
board
of,
does.
of power, and it does actually
It's the
streamline it.
powers of the
The
board.
the changes he's talking about actually do make it better for business because it eliminates some
It does.
steps. It allows us to take steps.
You're
that
gonna remove
normally
like
we'd
4
have to hand
months
off
out of the
to
I
process
appreciate
here.
that.
Yeah,
I'm just saying.
and that saves them
We
months.
do a good job as we are now.
I think we're a little off topic as
There
it
is.
relates to the water supply, but hey, you know.
Is that
No,
we're
no, no.
letting things slip through.
No,
No,
so
no.
I want to clarify that comment.
Uh,
If you've come to any one of my meetings, and I know you've personally not come, and I don't blame anybody for not coming to the meetings, they are very long, but I would challenge anybody to come. I have done nothing but, even at the planning level, going back to my first term on the council, I have done nothing but compliment the planning board. I think that the planning board in North Smithfield does a fantastic job of vetting out any application, and the reason for a lot of these changes is to actually memorialize anything that you guys have done or have started to do by best practice, so that any future planning board that may or may not think of the things that you guys have thought of is there as a guide to help direct future planning boards, to help direct the future planning department in terms of what we expect from an applicant up front, so that the rules are known and that things aren't changing. So it's not to say that the planning board is missing anything. It's also, we have to be cognizant that the state law is changing and that, yeah, things are going to change in terms of how the planning board operates, but it's not a slight at how the planning board is currently operating in today's nature.
Okay,
Again, I shouldn't comment, so I
That's okay. I appreciate the comment.
I'm going to keep us on task about what's in front of us here, as
Yeah.
opposed to
we're okay now.
talking
We're
about
good.
other things that's not on our agenda. I want to thank you, Councilor Ogier, for taking the time to meet with the businesses. I listened to the town council meeting when this was up for review and comment during the public hearing that was had. So, and it sounds like, you guys are making steps forward. You're making good faith efforts with existing business owners. So again, I applaud you and your board for taking that time and, going that extra mile to continue this process. I know I was the one that voiced some hesitation at the last go-around. After hearing all the comments and everything from that town council meeting and what you've provided us with tonight, it still sounds like you got some homework to do. But I personally, after hearing everything moving forward, I'm happy that I've been satisfied with what I've heard. So certainly can agree with the planning office's recommendation that this is that we provide a favorable recommendation to the town council.
Thank you. Doug, I'm wondering if you can speak to some of the conversation we had, including last evening, about some of the changes we are considering in terms of, from the way the changes are written now to, and it's sort of along the lines of, as you said, let's focus on the land use, because maybe we can alleviate some concerns there. But even in terms of, and I think one of the things I brought up, there was a sentence or a clause in there that seemed to be duplicating something. Oh, it was about the peer review. Mm-hmm. And, my own feeling is that it's unnecessary to have that in there because the planning board now has the ability to require peer review when we deem necessary, correct? Is that correct? Correct. Right. So it doesn't need to be in there unless it's being mandated, and yet the wording was suggested to be changed from shall to may. Well, once it becomes may, it's no longer mandated, in which case, let the planning board do its job.
Correct.
So I'm hoping that's a change that will go into the final version.
It will
personally.
be, and the only reason
Okay.
for the CAVA, the technical assistance is, or the peer review, there's a lot of ordinances that relate to this type of topic. They have a separate section.
Yeah.
But if you look further down in the ordinance, it does say that regardless of what board is hearing, the criteria here in the application, that the applicant must comply with all rules and regulations of the board. So I think the intent was to just provide clarity, but yeah, there's going to be some changes related to language and duplication for sure.
Okay, great. Because I think that simplifies it, and as you keep simplifying, there's less room for misinterpretation and all that kind of stuff. You know, that's usually less is more when it comes to that. So, any other questions, comments? Do we have a,
I do have one question.
okay,
So I know that the highlight has been, you know, this area along Industrial Drive, but we also have areas of residential that's falling within this district. Are you and your board looking to anything about, not every piece of property that's located in here is connected into the sewer? So are we also looking at things for residences like that? So in the event that they have a septic system, or God forbid they have an existing cesspool, which I hope they don't have at this point. But if are there updates that you're looking at for the residential side of things as well?
At this time, we have not gone down that route. What the board has done is, was in the process of successfully obtaining a grant from DOH, one of these mini grants to help promote and further education to residents, and trying to take an educational approach in terms of, you know, how to protect groundwater resources in your area, specifically within a watershed. It was highly received at DOH, and we're in the process of finalizing that. So there's more to come on that, and it's a shout out to the administration and to the planner for assisting in that as well. And so that's kind of the approach we've taken. And follow up to that, some of the other conversations we've had, some of the local businesses, is, you know, how to create more of a partnership between government and the local business community as well, or strengthen it as it relates to education of water resources in those areas. You know, I think not many people, and I'll admit it was a good educational session on September 6th as it relates to all the regulations that they currently go through. And so I think, you know, to curb any misperceptions or misbeliefs out there of kind of how water is, I think there's ways to partner with the business community to help highlight how their water is being protected as well.
right,
So more education on that manner.
all right.
And at the same time, the board has also recommended looking at, and I said it during the public hearing, at a future point in time, should the town look to hire or partner with a consultant for, as an engineer, and is there additional training that can be provided for the fire department through EPA certification, which currently exists, as ways to help with inspections, et cetera, like that, and further training as well, just so, as ways to kind of look at it, regardless of what happens with the ordinance.
All right. Mr. Carrillo, did you have something you wanted to say?
Well, there were a couple of things, but I think there might be some people here.
Yeah,
I don't know if
that's
they're here to speak, so
Okay.
I'd wait to hear from them.
Oh, okay, fine.
Yeah, I can step
If,
down.
if, this isn't a formal public information hearing, but if anybody does have something you'd like to say, I would just ask you to come up to the podium and
Yeah, I can
introduce
step down,
yourself,
come back. It's not a problem.
if you don't mind.
Yeah, no,
Thank you.
it's good to hear from people.
Yep.
Good evening, Mr. Chairman, members of the board. My name is Paul Balarjian. I'm here as a taxpayer and a business owner. If you looked at the public hearing before the town council, you heard Gary Osofsky outline why, in his opinion, this ordinance is not required because of what you folks just said. You're the gatekeepers before the zoning board even touches it. And you've got the expertise to be able to do that. Now, I've represented the zoning board for 15 years, and I represented this board for 15 years. In all that time, you are meticulous, your predecessors were meticulous in making sure it was a fair hearing, and you had the criteria to judge it. But in this case, I want to point out some of the problems I think exist with that criteria. And I want to start with, and it's not very long, just bear with me. Non-conforming uses. They're indicated that if it's discontinued for 1 year, it shall not be resumed. That's contrary to state law right now. State law says it's the intent of the landowner to abandon the non-conforming use. And the famous case is the pizza oven case, 32 years later, coming back and reestablishing the pizza business. So just because the use is discontinued for 1 year doesn't mean it's over. So that on its face is in violation of our current law. The technical assistance side of it, you touched on. This is not supposed to be an adversarial process when you're in before the planning board or the zoning board. You want to welcome businesses in. You want to say, hello, come on in and tell us what you want to do, just like these folks did a few minutes ago. But now it's developing into an adversarial situation because of some language. For instance, to review an application under this ordinance, the zoning board shall engage a licensed professional geologist, hydrologist, soil scientist, etc. Now, that zoning board is quasi-judicial. You guys already know that. They're supposed to make findings of fact after they hear the evidence. But this goes on to say that person is going to determine whether or not the application is properly before the zoning board. That's the purpose of the zoning board. That's the purpose of you folks as the gatekeepers. But in this case, that licensed engineer is acting as a ex officio member of the zoning board. He also can be called upon to present testimony. Zoning board has no authority to hire an engineer. You folks know that. They don't have a budget to do it. Your legislation in the general laws creates your authority, as well as the zoning board. Zoning board is supposed to hear variances, special exceptions, and appeals from the building and zoning official. In this case, it's a super majority created by putting this guy, or person, or female, whatever, on that board. So if they have to engage somebody at the outset, you've got an adversarial proceeding going on. And I think you talked about that a few minutes ago. But it basically overrides a major portion of what the ordinance says.
Excuse me, could I just get clarification? Is what he just talked about with the hydraulics and that equivalent to what I was saying about the peer review? Okay, but what I, well, if it's wording with shall, then it does say that, but you're actually saying you're taking that out.
I don't think I heard that. I think I heard may.
May, but may is how the current ordinance is constructed right now.
And because it's may, it should be taken out because it means it's
They don't have the
voluntary.
authority to hire anybody.
Right, but I'm just saying
I mean, because now you've
it's
got the
redundant to
board
say it.
acting not as a fact finder, the way the courts do. You're actually presenting testimony to counter the applicant.
No, understood, but,
And why act that way?
right. Well, we make a decision on a project-by-project basis whether
I
a
agree
peer
with
review.
you. I'm not challenging that.
And that's all, this ordinance should not cause it to be any other way.
But it
And I bel-
overrides.
My understanding is that, right, my understanding is you will make sure the wording is such that it does not force that. So I think,
If
I'm
the-
just saying, I think your concern is valid, but it's going to be addressed.
Okay,
That's what
all
I'm
I
saying.
want to make sure you understand, even if you use the word may, you've created the adversarial
Yeah.
relationship.
I agree.
Now, in addition to that, in the 6.19.8.3, it indicates that it's going to be reviewed by other town boards and agencies. What does that mean? There's no other boards or agencies to have an application review. It's either here or the zoning board. Now, you've got state permits that have to be satisfied, RIPTs and everything else, like you heard tonight. They've got the current expertise, and it covers the town of North Smithfield. Any businessman that operates in this town is going to comply with those permitting requirements on a continuing basis. But this creates an additional leg, if you want to call it that, in that process. And it's not necessary. And then you don't even define what other agencies he's talking about. And that gets into another issue. The notification for businesses when there's an application pending before you is now going to extend to other town personnel, or other boards that have any jurisdiction. What other boards? There's no other steps required except this board and then the zoning board, assuming the town planner has reviewed the application. And the section I'm talking about, if the planner wants to look at it, it's under 6.19.8.3. Now, there's a new section in here also with regard to 6.19.84 under section 9. Any use that includes storage of chemicals or petroleum products must include installation of groundwater monitoring wells with scheduled sampling provided to DEM with pre-development water quality data. Now, it goes on to say that that data is going to be filed yearly with this commission. Do you know of any business in town that's required to do that by DEM? I don't know of anybody, because they have primary jurisdiction. The fire department inspects these facilities. The building inspector inspects them on an occasional basis, at least once or twice a year, except the business we're in anyway. So you're putting another layer in that hierarchy of requirements. The board also, this board, by authorizing the zoning board to do this, requires a lab analysis to be completed. Now, if they don't like that lab analysis, they can force the applicant to go out and pay for another peer review. In other words, it's double teamed. Finally, under enforcement, the zoning official is the first leg that's going to receive this application and work with the town planner, obviously. But the way it's worded right now, it's the zoning official or his designee. You're required by law now to hire a qualified building official / zoning inspector. He has no authority to delegate his responsibility to make sure the application's complete. But right now, his designee, what's the criteria? Now, the remainder of this apparently is also geared to the presumption that the applicant is not going to comply for some nefarious reason. In fact, we heard some of the people say, well, those are the good people that are coming in, they comply now. What about the bad actors? We haven't had too many bad actors, to the best of my knowledge, that haven't been prosecuted for violations of the ordinance, either the zoning ordinance or your findings. So that's the concern from the business community, just on a small scale. Gary got into it at length, if you listen to his testimony, and he told you why. We think this is an unnecessary duplication of what you already have for responsibility. And you're right, you are the supermajority here with regard to how it's going to happen, not an ex officio member of the zoning board. So thanks very much. Unless you got questions.
Doug, did you want to respond? Okay.
Yeah, just a couple of things, just to clarify. So the pre-existing non-conforming clause with the abandonment section, 619.7, that abandonment language is currently existing in the zoning code.
I understand.
So I just understood. I just want to be clear that that is not one of the amendments that was suggested. I agree with you that there has to be intent.
Can
I'm
I
not
explain
gonna,
that to you? For
I don't want to get into that discussion. I just want to make it clear that that is not something that was recommended by the Water Review Board. It's something
It's
that's,
in their ordinance.
I understand that, but it's pre-existing and currently in the zoning ordinance as we speak today.
All right, can I answer you, or you want me to wait?
No, that's fine.
Since that ordinance was written in 1972, Superior Court interpreted, you know where I'm going. You already know.
I do. I know exactly what you're talking. There has to be intent.
Okay.
There has to be an overt act by the property owner to abandon. Understand, I appreciate it, and I agree, and I don't disagree with what you're saying.
Fair enough.
I just want to make it clear that even if this ordinance failed, that would be something that would continue to exist in the current zoning ordinance, just so we're clear on that.
Right.
As well as the review by other boards and agencies. That is something that is currently existing in the ordinance and was not introduced by this group. The only change to that section was to change 45 days to 30 days to be in compliance with the Rhode Island general law for the timing. But the review by other boards and agencies, that language is pre-existing language currently in the zoning ordinance as it exists today. So again, if this ordinance fails, that language would stand, except it would say 45 days. I'm not arguing with you again that that's proper and correct language. I'm saying that it exists
Because the
today.
courts interpreted that language after 1972.
I'm not arguing with that.
Okay.
I just want to make clear that
So why repeat it under this ordinance?
No, no.
I'm not arguing that either.
got it.
I'm just saying that it's pre-existing, it hasn't been changed. If you're suggesting
what
that
I'm-
it be changed and eliminated,
If I
that may
could-
be something that they would
if I
want to
could-
take under
I could
consideration.
perhaps bring this together.
Yeah, I
Because
understand.
you're arguing two different points. Everybody seems to agree that if that is in conflict with Rhode Island state law, it's wrong. Needs
That's all
to
I'm
come
trying to
up.
point out. So you don't
And it is.
reassert
But the thing
it.
is, it's not, it wasn't part, what Mr. Krillo
I'm
was
just
pointing
trying
out.
to clarify
It
where the
wasn't something
language
that
came from,
new
that's
that was
all.
introduced, it's already there. But since the introduction is about amending the law, maybe we can correct that problem
I
now.
would agree with that.
That's what I would say, is let's correct that by removing it or whatever.
Okay, but all I'm trying to point out is, it's a reaffirmation in the current proposed
And-
ordinance.
Well, that's because it wasn't changed from the old one.
Well, I
But-
don't-
But I
once
think
again,
now.
I
it-
don't know that.
But I think now we need to make that change. This
Okay.
is an opportunity to clean that up.
Just, I won't go on, but just to clarify that, I don't disagree with what you're saying. I just want the room to be aware that that is not something that was proposed. That is something that currently exists, that's all.
Well, see, you and I, respectfully, sir, they're reasserting the same language here.
understand that.
So you're not making it better.
I
Correct.
don't disagree with that.
That's all I'm
Yep.
saying.
I don't disagree.
Thank you.
Ms. Dozier. Yeah.
I'll say it again, and I said it all along. The language in this ordinance, everyone wants to use the word adversary, makes it harder for businesses, et cetera. That is not the intent. The intent is to strike a balance to protect future planning land use that it feels as it relates to the current ordinance and land activity. With that being said, if there is ways to improve, forget the proposed ordinance, the existing ordinance that currently exists,
Right.
by removing any violations or contradictions to state law and to bring it up to a more formal code, we should be entertaining and discussing those. These are the conversations we should be having. You know, the groundwater monitoring wells, it says as a plan essentially submitted to DEM as part of your DEM approval criteria. If DEM says you need a monitoring well, that all this ordinance is saying is you hit carbon copy on your email of the report to the town, so it's on file. Just like I believe you guys currently do when you ask for well sampling and well testing sites.
Yep.
So that's the intent and the spirit there. I agree. If there is language that is confusing or that makes things more burdensome and is in contradiction with state law, when we got a review of this from a legal perspective, none of those popped out. So then that is something that I think needs to be thoroughly reviewed again.
Yeah.
And those things should be stricken from the current ordinance. I don't
Yeah,
disagree
and-
with anybody on that at all.
And again, where you're not quite done.
No,
with-
this
with
is still very much a work in process.
Then let's take a look at all the comments
Correct.
that he made, about the designee and all that kind of stuff. If these are inappropriate, now is the time to improve the language by taking these things out.
Correct.
Or rewording them to make them
And part of the
in compliance with state law, if needed.
And
But
part of the designee came, what happens if the zoning official is not currently in a position? Larry was in the process of leaving at that time, and the question came up, well, what happens if we don't have a zoning official? Who takes over the ordinance? We didn't get an answer, so we put a designee, assuming that there was somebody appointed as the de facto zoning official
Right.
in that instance. That's all the intent was there. But I agree, if it's contradiction, it should
Yeah.
be removed.
Yeah,
Can I suggest something?
Yeah.
certainly.
There ought to be a revamp of this ordinance based upon the input from all these different groups. And before you vote a favorable decision on it, reconvene, look at the completed master changes with even the approval of your planning director, and then take a vote. Because
Yeah.
right now, it's this
Yeah.
one.
So
If-
I don't know if the planner has comment, but the water commission has been discussing with the planner as well for recommendations and feedback as well.
Yep.
I don't know if to satisfy this board, if a joint meeting between the Water Supply Review Committee and the Planning Board is an appropriate function. I'm not quite sure there. But, you know, anywhere where we can gather further feedback to further make recommendations, whether it's the existing ordinance, which is what we're looking to upgrade or whatnot,
Right.
I think is valuable conversation.
Mr. Carullo?
If I may, Mr. Chairman, but, before we let the general public speak, my suggestion was going to be, there are still changes that are happening to this ordinance. I've been discussing changes with the councilman myself, and at this point, whatever ordinance was reviewed and recommended on is certainly going to be a different ordinance that's presented in the future. So
Correct.
I would also suggest, I think the councilman continued the public hearing before the
Correct, to
council
November
till
20th.
November.
Right.
So I would agree, and that my suggestion would be that as those amendments are being worked through, we can bring that back before this board for a future recommendation to the council on a tightened-up version or an amended version of the ordinance as to what exists today.
Yep.
I don't necessarily disagree with the attorney who spoke earlier about certain elements that are in the ordinance. I believe they weren't changed. I appreciate what he's saying. It's a recodification of something that's incorrect, and he's correct in saying that. But that is something that came from this citizen board that would not have a full understanding of those elements, and that if something was existing and they simply kept it in its current context, they wouldn't believe that there would be anything wrong with that. So
Oh, sure, it's
I
understood.
think we need
mean,
to
it's-
all,
Right.
come together and
So-
understand that and work towards whatever would be a reasonable solution. That's all.
So then, in respect for everybody's time this evening and the efforts that are still continuing to go into this, your meeting for the second hearing is November 20th, correct? So then I would propose that, I know the planning board meeting in November would be November 9th, which would be plenty of time to get things in for the November 15th deadline for the town clerk, that we continue this hearing and review to a date certain of November 9th, 2023, at which time we would have a more fully vetted, updated ordinance to review and recommend to town council.
Yeah,
And that's a motion.
okay, well, if, just for a little discussion, bro.
Don't we have to have a second for a motion?
We do need a second.
Do we have a second?
Second for discussion?
Second.
Okay, we have a second, so discussion. And following up to what Mr. Carullo said, one of the things I was going to say is that each time we have one of these in-depth conversations, bringing in whether it's the business community, and Mr. Ozovsky with his vast experience, all that, we learn something more. We get a different opinion. Sometimes things are going to be opinions, and, that's how it goes. But other things are just pure fact, like something being in violation of state law. And so, but out of each one, my own observations, since I sit on the Water Supply Board as well, is that we have some more changes to make. We have some more changes to make, because it's not quite right. Because we shouldn't be propagating erroneous language. I mean, that's an easy one. There are a lot of important changes made that I think are very good, because we've had places in different documents in the town where there's a different criteria being used, and that actually creates issues for the planning board on projects when you're in like a watershed area or something like that, because the attorney for the applicant may be looking at the interpretation that they read that was most favorable to them, and now everything is being directed to a state law or a DEM ordinance or something like that, because who are we to override DEM anyway? So there's a lot of work that's been done that I think is really important in cleaning it up. We're just not done. And so I would agree, so that's in agreement of the motion to move it forward, because it's going to give you more time. And I'm sure you're feeling it too, because there is just a lot new information, better late than never. A lot of good input from the business community, which is going to be more, and hopefully more residential input as well. I think some of the people whose lots abut that also have concerns that they want to discuss. So I don't know when the, like a full public hearing could be held, but I think that would behoove everyone. And
Public hearing.
I think you talked about it last night of having like a public meeting about,
I'd look to have as many public meetings as possible.
Oh,
with
okay, great.
Business and
Yeah.
representatives outside of the public hearing at the town council level.
so is it really a matter of kind of promoting the water supply committee's meetings?
I think
to
how
encourage
those get
more
promoted
attendance?
definitely helps. I think what the ordinances look like since it was submitted to the council and where we are this evening is looking a lot different. And I
Mhm.
think there's ways to streamline and simplify like other ordinances
Yeah,
that look at, say, you must follow DEM permitting requirements, and then, you have your best uses or best practices sections outlined in other communities. So I agree with extending the public hearing. I hope that there is more feedback. It's definitely helped us to adapt and to change as needed. And that feedback is very valuable.
Yeah.
And the intent was to clean up language and to remove any
right.
contradictions, et cetera.
And I think for the next, I guess, water supply, just one second, to support that, I think it'd be good if we took a stab at the changes to 5.4, to actually
Yeah, I don't
look
know
at the
who's
land use
Yeah,
and propose changes, because I think that'll also ease, because right now there's still some unknowns, and there's a perception of there being sort of a blanket impact on business, and by showing those changes, they'll see it's not a blanket impact, right? It'll
Correct.
become the exception, the impact will be the exception and not the rule. Instead of right now, the perception is the impact, the burden is the rule.
correct.
And I think that would go a
Plus,
long way.
we're also tackling the trigger for if something was special use. It may
Exactly.
not say require a special
Yep.
use.
Quantifying
based
that.
on expansion
Yeah.
percentages, et cetera. So,
Because I
There's
think
still
we're
a lot
all
to
in
be done.
agreement that the trigger, the zoning should encourage as much good business as we can get in this town.
correct.
I'm pretty sure we're also in agreement, we don't want a coal-fired power plant in town, right? So that might be something we still restrict. But, we all want to get that, because we all need the tax base. We also have a lot of great land to promote, and North Smithfield is a good town for a business, because it's a good town for their employees. It's a good town, now we're getting a Starbucks. I mean, come on. People are going to start flocking here, so we got to make it easy to get in.
And any review of the land use table would also obviously need input from planning and zoning as well before it would get back to the town council. I would like to have those offices weigh in with,
Yep.
obviously, working with the administration as well to get feedback, just because those have impact on the comp plan, et cetera, as
Right.
well.
And I think that'll lay well to something that I'm sure the administrator is going to work on, which is having a really nice promotional and welcome packet for new businesses that you get from other towns, like the town of Smithfield, which first it's the promotion of why Smithfield, and then once you're a business member, it's, hey, welcome to the community, and hey, here's a little bit about how to work with us, how to work within this town, and be a good corporate citizen. And it makes life a lot easier, and we don't have anything like that in North Smithfield, and we should, because we should be promoting it. That's
Correct. I
That's
agree.
what good business is. Get your marketing done. I know my company doesn't do the marketing it should do. We make business, we make sales in spite of ourselves sometimes, So I think that's something we should do as well. And cleaning this up is going to support that.
Right.
So,
Mr.
Great.
Chairman,
Oh.
point of order that we have
Mr. Chairman,
discussion.
point of order.
Hmm.
Once there's a motion on the floor, I don't think it's appropriate to have further discussions. The motion's supposed to be called.
You can have discussion,
no, we can have
as
discussion.
long as you second with discussion.
Am I correct or not? It's something we should
I-
research for.
I see it,
But I
well,
think-
I've seen
I
it at the
think-
town council meetings. That's why
I
I
think,
thought it was appropriate. I didn't think the rules would be different.
I think if you want to have a discussion, you need to second with discussion, but I think if you're going to continue
Oh.
to allow public comment, you should rescind your motion and your second.
Okay,
Continue the public conversation,
okay,
then make your motion in your second to extend
okay.
it.
That's for future. right?
Okay, appreciate that.
So I'm going to step down.
All right, thank you. Okay, so
We have a
we're back
motion.
to a motion that
Motion
has
to
been
continue.
seconded to continue. Roll call vote. Dr. Bryant?
No, because I think we should wait
Oh,
for
oh.
January.
I'm sorry, what?
Yeah,
Oh, I'm sorry, you had your, but at this point, should we rescind the motion now? Yes,
Rescind the second.
Rescind the second.
so we have to rescind this,
Rescind the
I'm
second.
rescinding my second.
Amend your motion, second, amend the motion, then your, withdraw your motion. Then
Yes.
we'll be back to
I will
I'm withdrawing my second.
I will withdraw my motion.
Okay. Great. There you go, Mr. Zadowski. Thank you. Thank you, Mrs. Wallington. There's no Robert's rules in engineering.
For some, this will be, repeat,
Thank you.
but for others not, so.
Oh, yeah, this is the glasses. This is good.
Gary Izowski, 88 North Main Street. I do have some things that I prepared, but I have to go back to a couple of the things that Attorney Balarjian addressed. And I think it points out, I guess, what I want to say. I mean, this process even is getting so disjointed that I'm not sure what to do. You know, I could hold my comments. I don't know where I'm going to be when the next meeting of this board is held, or if it will be held, or get bumped by the council as it was. I was here for that meeting. This is just getting as messy as this existing ordinance and as messy as the proposed ordinance. And it's unfortunate. I think I've made it clear from my first comments that I don't think we need this ordinance. I said it back in 2006. I'll keep saying it. And, you know, I don't represent anyone. I am a taxpayer. I've been active in town affairs for a long time. I know what this board can do as a former member of the board. And I understand what we need in North Smithfield from a dimension that I think few can appreciate. You know, even the whole process. This board is hearing from the chairman of a committee, but also a member of the committee that appoints the board. We've got two members of this committee that are voting members on that committee. And, you know, the process, folks, matters when you go through it all. And it's not what I expect of this town as an operation, frankly. But that said, back to, you know, the comments about DEM offering a schedule for monitor wells, for maintenance or for sampling of monitor wells. That would be an extremely new, well, that would be a very new experience for me to see the DEM prescribe a sampling schedule for a site that doesn't have a release. Because frankly, I don't believe DEM has any authority to be able to put forward a requirement for sampling on a site that it doesn't have, on which it isn't acting on a release. We're delegating, you know, some of the language as it sits would say, well, you're going to monitor this the way DEM tells you to. Well, if you have a release, you do, meaning a release of a compound that has impacted the groundwater. But absent that release, DEM, I'd be surprised that you get any kind of a offering of a required schedule for maintenance from DEM. We've got a new member sitting. I don't know how these things have handled when other decisions are before the board. I feel an obligation to repeat everything. I won't do that. I'll make myself available to questions if that's appropriate, but so I don't intend to repeat all that I offered at the last meeting, or the last time we were here for this discussion, but I'll certainly provide any information or answer any questions that anyone has. I want to start with an important question, though, because as these discussions have gone on at the Water Committee meeting and the Review Board meeting, and again last night, even to this point, there seemed to be confusion about what happened in 2020. And I go back to that. On September 3 of 2020, this planning board, including 3 current members, unanimously voted to remove the 2 manufacturing zones from the groundwater protection overlay map. It was ruled consistent with the comp plan, as I believe it was at the time and continues to be. Did that action create a condition where, and this is the question, did that action create a condition where any business could come into the area to do anything they wanted? Because that's the language that's been used as a perception of the concept that that pink area was removed from the overlay. Can we all agree that the parameters of the district use regulations and every other zoning application still exists and is an obligation of, or is in effect for an applicant that comes before this board or the zoning board as it relates to that area? That pink area only excludes the application of this overlay. It doesn't throw away the zoning ordinance. And that's the impression that 1 or 2 members of the panel have evidenced over time. That's unfortunate. It's part of the misunderstanding, I think, that even brought about this ordinance in the first place. So I also want to make, with that done, I want to make sure that the following section in the town's comp plan is considered whenever this is finally decided, because in the section titled Non-Residential Build-Out Analysis, it says, and I'm going to read it, quote, "The economic development element calls for an aggressive program to attract new, quality industrial and commercial development to North Smithfield. In addition, it suggests measures to assure the retention of existing business and industry. This economic development element encourages a type, scope, and scale of industrial and commercial development that will result in the creation of quality job opportunities and expansion of North Smithfield's tax base, while at the same time preserving North Smithfield's unique character and environment. This is best accomplished by encouraging redevelopment within existing commercial and industrial areas and establishing corridors of commercial and industrial development in designated areas that are near transportation facilities. A detailed build-out of all non-residential zone districts was performed using GIS in 2014 aerials. The findings indicate that North Smithfield has very little undeveloped commercially zoned property remaining. As a result, the town must consider both flexibility in its subdivision and land development process to encourage development of remaining industrially zoned land, along with potential zone changes to add to the town's industrial base." That's the end of the quote from the comp plan. We have substantial acreage in our industrial zone on both sides of 146 and on Quaker Highway that's undeveloped. Making any portion of that area more challenging to develop is not in the interest of the town. Now, everybody's favorite dinner table conversation, soil and groundwater systems. It's great stuff, I'm sure you talked about it at dinner. In the handout that I provided you, the top 3 pages are from a September 2009 document from DEM regarding groundwater classifications. It's important to understand that document as it relates to why we have a protection overlay. Since its inception, the area delineated for protection in the northern portion of our overlay ordinance has been based upon the existence of a GAA classified groundwater. The basis for a GAA class in our case is the first item listed in the qualifications in front of you. That quote says, "The state's major stratified drift aquifers that are capable of serving as a significant source for a public water supply." That entire blue area up there is labeled, is identified as GAA by DEM on that premise. This is important in that the resource DEM is citing is a saturated, highly transmissive soil that can be used for a public supply, which are built very differently from homeowner wells. Public supply wells in these zones can produce flow rates in the multiple hundreds of GPM. So GAA areas are not classed for their use by individual homeowners. In fact, since most homeowner wells today are drilled into bedrock, it is a given that many homeowners in that area have actually installed wells that pass right through the aquifer, that highly productive zone, to be finished in bedrock well below the land surface. The key point here is that the preservation target is for highly productive well installations in these GAA saturated soil zones. As I detailed the last time, the existence of chlorinated solvent releases in or adjacent to our industrial park, not to mention the intensity of land use itself, will prevent the Rhode Island Department of Health approval for a public supply well in that area for generations. We have, I will repeat portion of this, at that far end of the, can't do this, the far left end toward the bottom of the pink area is the Amprex release, a chlorinated solvent release that is still being cleaned by a responsible business that unfortunately had an accident back in the 60s. It's a large corporation that can afford, apparently, to be able to pay the bill. It's the fact that that corporation is behind this is the only reason that that's not a Superfund site. There's somebody there paying the bill. The distribution from that release is very similar to the distribution from the other one that's in the deeper blue area on the other side of the northern portion of the pink zone, where the stamina mill problem occurred. Same thing. Difference between stamina and Amprex is that there's no one there to pay the bill. It's a Superfund site. Putting a public supply well in that area, given those two circumstances, is just not going to happen. The Rhode Island Department of Health, I'll go back to what I said before, those kinds of releases, the professionals who remediate those don't talk about remediation in terms of years. They talk about remediation in terms of generations. We're not looking at any time soon that either of those things is done. In the work that I did, we often said that we spend 10% of our clients' money recovering 90% of the compound that's been released. We spend 90% of their money chasing the final 10%. That's what's happening here in both of those locations. So please keep that in mind as we look at this. Whether it's the ordinance that you want to fine-tune language, okay, I guess, but you'll never get me to agree to that. I don't think we need it. We've got a planning board, we've got a zoning board. If they do their jobs, we're fine, and they have for decades. And frankly, I think the only time that this board has had an issue with this or has had this ordinance come into play is when the North Smithfield Auto Body debacle came to play. It was over this ordinance. It was a mess with competing, experts and more. Well, it was a mess. I think we can agree. So next is a map from DEM. It's the colored map, and it shows the groundwater classification across the northern portion of the state. It's this one. Maybe a little difficult to see some of the things in it, but in the upper central portion of that, the big blue area, I think it says Slatersville right in the middle of it. There are two yellow-orange dots in the middle of the blue. One of those, the larger one, is the LR&R site. That is a GB groundwater site. The other little smaller one to the left that's right on the Burrillville line is the Western Sand and Gravel site. That also is a GB site, right in the middle of the darker blue, which is all the GA. And that darker blue is that same, it's in light blue on this map. Right next door, you've got the city of Woonsocket. The entire city is GB. Down at the bottom right corner of this map, you've got Providence, some portions of Pawtucket. If I expanded it more, you'd see East Providence, all GB. Those zones were established by, but in the middle, there's between Woonsocket and Providence, there's a medium-sized orange space. That's the Lincoln Industrial Park. The blue is GAA, this green is GA, the yellow is GB. Why am I saying all of this? Is it that we expect every portion, every ounce of groundwater in the city of Woonsocket to be foul? Or Providence, or Pawtucket, or East Providence? I'll say to you, no, that's not what we should glean from this. What we should get from this is to understand that when DEM did these maps initially back in the 70s, I would expect, there was assumption made. And lines had to start and stop somewhere. And our urban areas were just presumed to be areas where groundwater had been deteriorated to the point that you couldn't assume it to be ready for consumption without treatment. That's what the GB area is. Could you prove that you could put a well in some of those areas and consume it? Yes, I think you could. You have an uphill fight with the Board of Health, because the Board of Health is going to say, well, how do you know that you won't eventually pull something in? So there's some supposition. Are there individual sites within Woonsocket and Providence? Of course, just like there have been sites within North Smithfield. The Lincoln Industrial Park, the oldest release that I'm aware of there is the Lincoln Dimensional Tube site. 110,000 square foot building that I looked at many, many years ago, and I think could have acquired by just signing my name, because nobody wanted to own it. Another solvent site that has impacted, had impacted groundwater into residential zones. Now a GB site. My point here is that, well, I have to go to the next 2 pages before I conclude, I'm sorry. The next 2 pages are tables from Rhode Island DEM which provide the cleanup standards in their management of remedial actions. If you note on the first page, you've got the GB standards. Maybe I have it the other way around, I'm sorry. You've got a table that shows the GA standards and a table that shows the GB standard, the first one being the GA. And if you look at benzene, which is a component of gasoline, the groundwater objective is 0.005. Now if you look at the groundwater objective in the GB zone for the same compound, it's 0.14. It's 28 times higher, meaning if you're cleaning a site in a GA zone, you've got to get down to 0.005, 5 parts per billion. But in a GB zone, you can leave more of that compound behind. 140 parts per billion is okay as it relates to groundwater. That's where I think it's important that we learn from what DEM does. DEM looks at areas and says, if it's a GB area, we're not going to require it to be cleaned to the area because we expect that it's not going to be consumed. It's not going to be consumed without treatment. They recognize the need to be considerate of past events and actual exposures. My advocacy is to leave our industrial areas out of the overlay protection zone as it is now, and it is based on that same philosophy. We have a large GA zone, GAA zone, and, well, we have an even larger GA zone. A GA zone is similar to the GAA in that it's presumed to be appropriate for consumption without treatment. It's just not going to be the high capacity that the GAA can produce. We need to treat it the same way that DEM does with levels of increasing or decreasing concern. If we're to act with consideration to rational science, knowledge of the impact that exists from a time when we had far higher hazardous material use, in the late 90s and into the 2000s, as I was managing waste transportation, hazardous waste transportation, we saw an 80% decline in the volume of hazardous waste disposed. It wasn't because people were hiding it. It was because people weren't using it anymore. They had found other ways to be able to run the same processes without creating the volumes of waste. And we've heard some of those circumstances. The one that was a surprise to me just in these discussions was to learn that Anchor Subaru's garage floor drains don't leave the building. They don't leave the site. They all go into collection. The water gets evaporated. There is some residual that gets dropped into a tank, and that is disposed. That's what's happened in terms of management of risks based on DEM and EPA regulations that I'm very confident protect us from the kinds of things that we have seen in the past. So, leave the overlay protection map just as it is. That is particularly true if we are to adhere to the elements of our comprehensive plan that advocate to make it easier, not harder, for business to locate in North Smithfield. I'll conclude with focus on the town's economic condition. In my recent advocacy for supporting construction of a new police station, I encourage that we look back to the 10-year period of the mid-50s to mid-60s, where a North Smithfield population just about half of what we are today acted to build a middle school and a high school, Hallowell School and the high school, in less than 10 years. That smaller community approved what in today's dollars would be something in the range of $150 to $200 million. Looking back at that, while we anguish over spending $18 million, it caused me to wonder how they did it. And it was only after the meeting that it hit me. The other major matter that took place in that period was creation of Industrial Drive. It was the new business revenue that had to be their justification. We had a growing business community. Industrial Drive didn't exist until sometime in the late 50s, early 60s, and it was being populated. It was the new business revenue that had to be their justification. The concern I've expressed again and again on this matter since 2006 is to encourage recognition that our regulations are economic architecture. It's a term that came to me from the former director of the Department of Business Regulation, who himself was an architect. The rules we put in place can inspire or depress economic activity. Returning this ordinance to cover our key industrial areas where there is no chance that the groundwater will in fact be used for public supply is the wrong architecture. Thank you.
Is there anyone else? Are we back to, it's time to vote? You can re-motion.
All right. I'm going to make a motion to continue this to the November 9th, 2023 Planning Board meeting for a review of the updated ordinance that will be supplied to us at a later date.
Okay, and a second? We have a second. Okay, roll call vote. Dr. Benoit?
No.
Nope. Ms. Marandola?
Yes.
Mr. Porter?
Yes.
Mr. Menard?
Yes.
And the chair votes yes. So, thank you all for that. Mr. Rosowski, thanks for that handout. That's very, it's good to have that explanation of the various water classifications.
Mr. Chairman?
Yes,
If
sir.
I may direct a question to our planner. Would you possibly, or would you please, get an opinion from our solicitor if the two members of the Water Review Board have to recuse from the planning board?
Okay, anything else?
Make a motion to adjourn.
Second.
Second? Those in favor?
Aye.
Aye. Opposed? No. We are adjourned at 8:39.